SJC-11637, Commonwealth v. Ilya I, juvenile.
Before you begin, Chief Justice Gantz has asked me to inform all of you that he will not be presiding over the proceedings this morning because he is attending the funeral of late Justice Neil Lynch. He will be reviewing all of the oral arguments, and he will be participating in all of the decisions of the court, with the exception of the bar discipline case scheduled last for this morning, because he's recused from that case. We'll begin. Okay.
Good morning, and may it please the court. I'm Gail Strassfeld. I represent the juvenile in this case, who asked this court to affirm the dismissal of the delinquency complaints against him. The question before this court and the question that was before the juvenile court judge was it more probable than not that the marijuana found in the juvenile's possession was intended for distribution rather than for his mere possession?
More probable than not. Is that the probable cause standard?
Yes, Your Honor, it is. This court has said that in at least three
That's
previous
not the
cases.
preponderance standard.
No,
It's
I don't think
more probable.
More probable than not. It's not a possibility. And what I would say is that in the totality of the circumstances here, all you've got is a possibility that it's an intent to distribute rather than mere possession. And if you look at the totality, it's based on the police narrative, which was attached to the complaint, which is part of what the judge below looked at and part of the four corners of what this court looks at. You have 4 teenagers hanging out on Washington Street in the Codman Square area. It's where the juvenile lives. He lives around the corner. And it's a Friday afternoon in the summer, well, early summer, June 1st. And a male and a female come up to the 4 juveniles, the 4 teenagers, and have a conversation. The male and the female and 2 of the teenagers, the police report doesn't say which 2, go around the corner to Southern Avenue right off of Washington Street. A very brief interaction takes place among those 4 individuals. Then the 4 individuals walk back up to Washington Street. The male and the female depart. They go inbound towards like downtown Boston. On Washington Street, the 4 teenagers continue down Washington Street towards Talbot Avenue. An officer sees all of that, notifies other officers in the area. It is an area of crime and of drug activity and gang activity. So other officers who are at the McDonald's, the corner of Washington and Talbot, they're coming towards the 4 teenagers, and the 4 teenagers see them, or at least the officers think they see them, and they hurry away from the officers. I assume they're going to turn the other way. The officer's attention is directed to my client, the juvenile, who crosses Washington Street in a hurried manner, looking back once or twice towards the police officers, enters a parked car on Washington Street. The police report does not say that any of those other teenagers that he was with, that the juvenile was with, enter that car. The car, after 2 individuals from that car leave the car, walk down Washington Street. I believe if you follow the narrative, they're going inbound for about a block. Police report doesn't say that they see them doing anything. Police report doesn't say that they see them interacting with anybody. The car leaves its parked space.
With the juvenile still in it?
The juvenile is still in it. Drives for about a block. The police report does say it goes 2 times out. I'm not quite sure what that means, but it does leave the parked space, drives about a block, picks up the 2, I think they were kids, picks up the 2 kids that had walked out of the car. They get back into the car. They drive a little bit. They take a left. They take a right, which happens to be the street where the juvenile lives. They drive a block. They stop at a corner, still on the same street where the juvenile lives, and it's intersecting another street. At that point, the police make their stop. They come up to the driver does not have an ID, the driver does not have a valid license, and there is the smell of unburnt marijuana. There's an exit order. They exit, the juvenile gets out, looks down at his groin area twice. The police officer states in the report that that's known to be an area where, part of the body where people secrete drugs. And yes, there's a search, and there's 13 small baggies of marijuana found on the juvenile. That's the total of what the police report says. Well, I'm sorry, it's not the total, because what's significant is there is no amount given of the marijuana. There is a value of 0.
Well, obviously, it's not a value of 0.
Well, I don't know that, Your Honor. I don't know how it's obviously not a value of 0. The police...
13 bags of marijuana, value 0. Do you think
13
it
or
was actually
15?
valued?
I don't know who to answer.
Go ahead, over there.
Well, if the police thought it had some value, they had an opportunity to write what the value is. Apparently, it's a drug area. They would know what the value would be.
Well, isn't this a subject for testimony? You're just saying on the little inventory, just put 0.
That's correct.
Well, because maybe there's no, at that point, there's no assessment. We know it's worth something.
Well, maybe, well, I don't know. If it's for his personal possession, it may not be worth anything. I mean, I think that shows you that it's not, that it tends not to be for the sale if there's not going to be any value on it.
It could be such a trial. Isn't this a subject for trial, cross-examination, further testimony, expert testimony?
If you had...
Does the officer have to put a value down as part of the element of the offense?
I think that if the police officer does not put a value, then the police officer is saying that police officer doesn't think there's a value. And this is, it does... What it shows you is that there's no probable cause that there's an intent to distribute.
Well, a police officer, I assume, get 13 small bags. What is the police officer supposed to do? Guess? Well, let's see. If maybe $5, maybe $3 a bag, 40, or just put down this is a subject for later discussion.
Well, I mean, I think if a police officer has experience and this is a drug area of drug activity, the police officer is going to know, is it a small, very, very small amount of marijuana, or is there more?
What if the police officer just put a big question mark, since he or she doesn't know?
Well, then we would have a question mark. We would still not have...
Would you say, how does that weigh into the calculus of probable cause? I guess my point is I'm wondering how relevant what the figure is. Given the timing here, how relevant what the figure is that the police officer puts on the police report for value is to the determination of probable cause.
Well, one thing I would say, I think it was relevant to this court in Umberto that there was no value to the marijuana that was found in the juvenile in that case. And I think there's a relevance to if the police officers really believe this is going to be distributed, I think the police officer can give an estimate of what it is. And we know that police officers can say, well, this is a dime bag, this is a $20 bag, this is...
Suggesting that failure to put any amount might be indicative of the fact that there was such a small amount in the baggies that they couldn't even, well, I guess they could have weighed it these days. I don't know if people have those scales, but couldn't even hazard an estimate as to in excess of an ounce or less than an ounce, or, I mean, there's nothing to indicate.
Right, there's just nothing there. We don't know. I mean, they don't tell us how much is in, whether each bag is the same. They don't tell us how much is in any of the bags or how much is in total. We know it's a really small amount because it's in his pants and the front of his pants. So we know it's a really small amount.
Is your you went through the kind of the details of the facts, and clearly with respect to this issue, the drive in the car is far less important than I would think than the interchange at the corner.
Well,
yes or no?
I think that interchange tells us nothing.
Okay, that's what I wanted you to focus on.
Okay, I'll focus on that. We got 4 kids hanging out. It's their neighborhood. 2 people come up to them. The police don't say that they know any of these people have any history of drug dealing.
How does the judge know that it's their neighborhood if the judge is supposed to look at the 4 corners of the police report? Is that in the police report anywhere?
It is. Well, it doesn't say neighborhood, but if you look at Commonwealth's Appendix CA6, you'll have the juvenile's address. And then if you look at Commonwealth Appendix 5, you'll see the address of where they were stopped.
But did they get the information about his address at booking?
No, but the judge is, yes, they did. Yeah.
So at the time of the incident, what does the record indicate as to whether the officers knew that the defendant lived in the neighborhood?
Well, I think, Judge, you're allowed to look at the complaint when you're deciding whether there's probable cause. You look at the four corners of the complaint, and the complaint tells you this is his neighborhood. I don't see how we can disregard that.
Well, but we also know that there's a booking procedure between arrest and the issuance of the complaint, in which information about your address is given.
This is in the incident report. I'm sorry, Your Honor. What I've just said about the address is what the police learn. The police in the incident report on CA 5 and 6. CA 6 gives the address of the juvenile, and CA 5 tells the address of where he stopped in the car.
So let me ask you this about the interchange. If, in fact, the police had put in their report that the defendant was one of the ones who went down the street and around the corner with these two people, would that have made a difference?
Might have made some difference. I'll tell you what would have made a difference if the police had actually seen an exchange or something.
Well, I understand, but frequently these things are not quite so obvious.
Well, I think this
That's why they went around the corner,
well,
presumably.
I think this, but they saw, the police officer says he sees a brief interaction. He doesn't say he sees an exchange. And in Commonwealth versus Levy, this court said, you know, if you don't see an exchange, you don't say that you see an exchange, it's going to weaken the probable cause evidence. You're just not meeting it. I mean,
was it defendant? Was this juvenile one of the people involved in this interchange? Whether
we don't know. We have no idea.
We don't know if he was the one of the four.
I would say that he would tend not to be. If you take the Commonwealth
he was definitely one of the four. We don't know. We don't know if he was one of the two. We don't know if he was one of those two.
The report doesn't say that. And frankly, if the Commonwealth thinks there's an exchange at that on Southern Avenue, and that the juvenile was one of them, the juvenile has no money on him when he's found. When he's picked up, he has no money. So what sale is going on with him? He doesn't have anything on him. He's got 13 bags, but he doesn't have any money. So I would think you could draw the inference, a reasonable inference, that there wasn't a drug exchange and that he wasn't involved in that interchange there.
I think this case is out. Chief Justice Gance's case about the four
Yes.
individuals. Can't remember the name of it.
Stewart.
Stewart, right. I think this is like Stewart. Four individuals, nobody can see an exchange, so nobody knows whether anybody, or which one, even if there was an exchange, did it? No.
I should know this case. The way you're talking about it, it sounds like I should know this case.
I think the Commonwealth wrote a 16L letter about it, right? Somebody did.
Not in this case, I hope.
I think it's Stewart. I think it might.
Well, if you could.
Oh, it's in another case. You're right, but yes, it is Stewart. But right.
So I'm sorry, I don't know I don't know what issue was in the case. If it was a probable cause case.
An exchange on Washington Street down here in the old combat zone, not in that Washington Street in Dorchester.
Well, I think, I mean, I don't think you can tell, if the police don't tell you anything, I don't see how you can draw an inference that there's been a drug exchange and that there's probable cause, that there's an intent to distribute the marijuana that the juvenile is possessing. I don't think that, if I can go through are there other questions about that interchange?
Well, I'm just, it's true that the number of bags is very, well, it's certainly a lot more than in Humberto H.
Yes.
And the circumstances of looking at a kid in school versus a kid on the street who's looking at his groin when taken out of the car or when he exits the car. You would acknowledge that this is not as strong a case for you as Humberto H., right?
Well, what I'll say is, yes, there are 13 bags and Humberto was 5. I don't know how much was in Humberto's bags. I don't know how much is in these bags. These could be, it could be less marijuana in these 13 bags than there were in the 5 bags in Humberto, number one. Number two, that the fact that the boy looks down at his groin area seems to me very similar to the fact that the juvenile in Humberto had an agitated demeanor when the principal goes up to him and starts talking to him. I mean, he's nervous. He's nervous about having the marijuana. You're not supposed to be possess the marijuana. It's a civil penalty. You know, maybe his parents are going to get angry at him if they find out he's gotten, you know, has been smoking marijuana and is going to his house to go smoke marijuana. I mean, I don't know, you know, these are teenagers. They can be afraid of all kinds of things, especially of the police, being nervous in front of the police. So I think, yes, of course, the facts are different, but I actually think that there's no more here that gives you probable cause than there was in Humberto that gave you probable cause. I think that's my time. I just wanted to say that the fact that the judge, the issue about referring to the probable cause for the motion to suppress, I think that doesn't really change anything. It was clear that he was acting on the motion to dismiss. That was what was before the judge. It was clear he says he doesn't find anything on the record not to dismiss. And, of course, this court's looking at it de novo. So when this court applies if you think he didn't apply the correct standard, then you're looking at it de novo. Thank you.
Thank you.
Good morning. May it please the court. Kaylin Campbell on behalf of the Commonwealth. We ask you today to reverse the dismissal of the complaint against the juvenile. I'd like to start by talking about the definition of probable cause. I don't believe, as my sister says, that it's more probable than not. She says that you say that this court has said that in 3 cases. I don't know what the 3 cases are, but in Umberto H, the definition is that there needs to be sufficient facts to warrant a prudent man in believing that the juvenile committed the crime as charged. And my sister left off talking about Umberto H. And I agree with you, Justice Botsford, that this is a different case factually than Umberto H. In Umberto H, this court talked about what probable cause is and what probable cause required. And this court specifically said that it does not require the same specific evidence of each element of the charged offense. It needs to be something more than suspicion. The court also said that in dealing with these possession with intent marijuana cases, that we need to take into mind that this ballot initiative did pass in 2008 and that the voters wanted to treat people who possess drugs differently than people who deal drugs. So taking all of that into consideration, I think the specific inquiry in this case is what are the facts that we can point to in this specific police report that support that this defendant probably possessed this marijuana with the intent to distribute it. Now, of course, intent is hard to define. It often relies upon circumstantial proof. And I think if you look at the totality of what is presented in this police report, it does support that this juvenile probably possessed this marijuana with the intent to distribute it.
You're using probably again. I thought you just said probably wasn't the standard.
It's not more probable than not.
Okay.
It is probably, considering common sense and the facts that are known to people in their everyday life. And when you look at the police report, what you have here that you don't have in Umberto H is you have police officers that see what they in their training and experience believe to be a drug transaction. Now,
But what is that? What do they see other than a group of teenagers on the corner interacting with each other? How is that different from just being on the street corner?
Is it the best facts that I've ever seen that describe a drug transaction? No. But the question is what police have to put in a police report to support to believe that it is a drug transaction. Certainly at a motion to suppress.
Oh, so you're saying there was something that they didn't put in the police report? What is it in this report other than the 13 bags that would suggest an intent to distribute?
I would point to 2 specific factors. The first is that you have a group of individuals where there's 2 people acting as a lookout. I would say,
Where is that?
sure,
It's not in the police report.
I disagree with that, Your Honor. If you look at the the first full paragraph, which begins, officers were conducting surveillance, it says 2 of the males stayed on Washington Street and looked up and down the street, while the other 2 males had a brief interaction with the male and female on Southern Avenue. I would say that looking at those,
On, please.
unfortunately, it was miscopied in the Commonwealth's appendix, but it is in the defendant's appendix.
It's page 1
It's page 1, correct.
of the appendix in the red brief.
Now, looking at those facts, taking in the light most favorable to the Commonwealth, with all reasonable inferences drawn towards the Commonwealth, I would say that that would support that those 2 individuals were looking up and down the street trying to evade police detection. And that's important because, as we all know, possession of marijuana isn't a crime. Selling marijuana is, possessing it with the intent to distribute is. I would point specifically to that fact. But the second fact that I would point to, and this can be found going down, it's the 3rd paragraph, and the end of the 3rd paragraph, is specifically what the officer said about the juvenile's behavior when he's pulled out of the car.
Is it clear that the 4 juveniles that were seen leading up to this supposed transaction are the 4 juveniles who were in the car?
That's the way that I read it. My sister represented differently. It seems like they're acting as a group. It says when the officers approach them near the McDonald's that the group walks away. It then says that the juvenile gets in the car. I would say that the reasonable inference, looking at the 4 described, looking at the fact that they're described as a group and that 4 individuals end up in the car, I would say it's a reasonable inference that it is the same 4. But turning now to specifically the juvenile's actions once he's pulled out of the car, I think it's significant that the officer says in his training and experience, suspects commonly secrete drugs in their groin area. And suspects is an important word because it's not just people who possess drugs, it's suspect for a crime. So people who possess drugs with the intent to distribute them, hide them in this area. And the idea of concealment is important to this case.
If you were possessing, you would conceal too. I mean, that's what happened in Humberto, right? So what you have here is a lot of behavior that's consistent with either innocent behavior or just plain possession. So I'm looking for something that's going to tip the scales in favor of something more than a bunch of teenagers with some marijuana that they want to enjoy at some point in the future. What is it here?
Well, Your Honor, to answer that specifically, even seemingly innocent activities in the eyes of a trained investigator can take on special significance. And I think it's important that they say the area that these drugs were found specifically supports that that's where suspects hide them.
Yes, but isn't Ms. Vasfeld right that particularly for a teenager, possessing 13 bags of marijuana, it is a civil penalty. You know, if you're caught, there's things that happen with that and monetary consequences of that. You've got parental problems, perhaps. I mean, so does the fact that this is a teenager versus an adult, isn't that something that we could take into account here, or the judge could take into account?
It is something that Your Honor could take into account. I don't think that this court should look at it in isolation, though, because if it were just the nervousness, then yes, that would be problematic to the Commonwealth. But I think you have to look at it in terms of what the officers observed in their training and experience, what they believe to be a drug transaction, and then specifically that it's not just this nervous behavior when the juvenile sees the officer, but it's also that the place where the drugs are found is somewhere where the officers say in their training and experience, suspects hide their drugs.
Suspects of what? Suspects of people possessing marijuana?
It just says suspects where possession of marijuana.
What the crime is that they're suspected of.
No, Your Honor, I would disagree with that because I would say in the light most favorable to the Commonwealth, which the police report should be considered, that suspects means suspects of the crime of which the defendant is being arrested for.
Right. Does it make a difference, I guess, does it make a difference that it's marijuana rather than 13 small bags of cocaine packaged?
The specific drug, I don't believe so.
Why not?
Well, in terms of intent,
Yeah, in terms of what's going on here. I mean, I don't know, I'm just asking.
I don't believe it would, were the specific facts that we have on this police report.
So your theory, I take it, is that these four people, this was a joint venture of some
Correct.
sort. Because obviously, if there was a drug transaction, and if you're correct that there was a sale, there's no money.
Correct.
So somebody's got the money.
No, it would be our theory that it was a joint venture,
Somebody
especially.
else must have the money.
Somebody else could have the money, especially where it's not identified whether the defendant was one of the lookouts or one of the individuals who went to the alleged transaction.
So I asked earlier whether Stewart applies here at all.
I mean, Stewart definitely makes the Commonwealth's case weaker, even.
But then before Stewart, right?
I would
Four
agree with you.
individuals interacting, we don't even know if they're just talking or whatever
Correct.
they're interacting, whatever that means. And then walking away, milling about. And if there was even something, if there had been something different from here, don't know who, right? That's pretty much this case.
Correct. I will say, though, that Stewart was decided after evidence was taken on a motion to suppress. And I think it's premature to look at this police report and say we definitively know how the officers would testify. Certainly, we do know how the officers would testify to a certain extent, but I'm reluctant to say that it would fall exactly the same as Stewart, where that testimony hasn't come forth, especially where there's an indication in the police report that the officers were already conducting surveillance. So it's unclear what kind of information would be disclosed through discovery as to what that surveillance was, which may be dispositive in a motion to suppress. To touch upon my sister's argument as to the value of marijuana, I don't think that should make a difference in this case. If you look specifically at the section of the police report where that's contained, it's on page 6 of my record appendix. It's described as property, and merely it's the property that they seize from the defendant. And so, of course, to the police, the marijuana doesn't necessarily have a value because it's not as if they're going to sell it. It's simply contraband. But more than that, I don't think that it's necessarily even readily apparent what any quantity of marijuana is worth. The police officers would have to do further investigation. Certainly, some quality of marijuana would have a higher value than a low quality of marijuana.
I mean, if you look at this, they seized a cell phone, value 0. Well, that's not true.
Correct.
It's some value, but these are all just zeros.
Correct. And I will say that post-Umberto H. in the cases that have talked about value and how it could be indicative of possession with intent, it's certainly something that could change where the police officers do put a value in. This happened well before Umberto H. in the cases in which the courts assigned such significance to the value that was put in there.
Is value unrelated to quantity? Or is the question of value, it is what it is within the case law, but what about the question of amount, quantity here? Does it make any difference whatsoever if there was just a minuscule amount of marijuana in each of the 13 bags versus a dime bag or a nickel bag? Something. I understand that value sometimes and quantity get mixed up, but I'm just talking about quantity.
Yes. I admittedly, that type of information isn't here, and certainly cases have said that where it does say dime bag, it can be indicative of an intent to distribute because they're uniformly packaged. Here it just says that they're uniformly packaged. There's no specific reference as to how much is in there. It certainly would make our case stronger. I don't think, in light of the other factors, that it's necessary to prove the intent in this case.
Were the other 3 juveniles arrested?
They were not.
And the report does not indicate whether any money was recovered.
No, it does not. It just simply says that they FIO'd the other 3. So there's nothing to indicate that they even searched the other 3 passengers.
Nothing to indicate either that the police knew any of the 4 of them before?
Nothing in the police report, no, Your Honor. Other than they were in the area conducting surveillance because it's an area known for drug activity and gang activity. But other than that, no, there's nothing to indicate that they knew this specific juvenile or any of the other 3 juveniles.
Your uniformity of wrapping, does that come solely from the fact that they were all in small plastic bags? Or is
Correct.
there something else? So,
Correct, I'm sorry. In saying that they were, I was saying that uniformity could, here it just says that there were 13 individually wrapped small plastic bags. There's nothing to indicate that they necessarily were all the same size.
Or that the
Same bags.
bags were identical. I mean, you know, they might, like, sometimes you can have like a certain seal or
Yeah,
a certain
there-
color or
Correct, there isn't that.
nothing about that. We don't know if they're identical, we just know that they were all plastic.
We know that they were all plastic. We know that they were all found together within one larger bag in the juvenile's groin area.
Is there any evidentiary value to the fact that there were 13 bags contained within one larger bag?
I believe so. There is case law that says that the grouping of small bags within one larger bag can support an inference that they were possessed with the intent to distribute it. Certainly, in Umberto H., that didn't tip the scales in favor of the juvenile, but it is certainly a factor in light of the totality of the police report that this court can consider in asking whether this juvenile had an intent to distribute this marijuana. And I see that my time is drawing to a close, so if the court has no further questions, the Commonwealth will rest on its brief.
Thank you, counsel.